Abavunaana musango gw'okutta Suzan Magara kuliko Lubega Yusuf, Hussein Waswa, Muzamiru Sali, Hussein Katomiro, Abasi Musa Buvumbo, Abubeka Kyewalya, Muhammad Kasaliita, Ismail Bukenya, wamu ne Hajara Nakandi. Mutwala kkooti olw'oggwa omunaana bateekayo okusaba kwabwe mu kkooti nga basaba kkooti egoba emisango egibavunaanibwa bwe bategeeza nti baatulugunyizibwa ebitongole ebikuuma ddembe wakati nga bakwatibwa n'oluvannyuma lw'okukwatibwa. Omusango ne baguggula ku ofiisi ya ssabaabi wa gavumenti wamu n'okuleeta ebbaluwa okuva mu ddwaliro eryekebejja abantu ababeera batulugunyiziddwa ko n'obujulizi obulala.
A2, A4 and A7, Peter Wanda for A5 and A6, Zaina Nabkenya for A8 and A9. While the state, on the other hand, is represented by Chief State Attorney Sharif and Nalwanga, Chief State Attorney Chomuhendo Joseph, and Chief State Attorney Irene Achimbugwe. Applicant submissions. It is the applicant's submission that they were arrested, detained, tortured, and inhumanly treated by the officers during their detention at the designated places. They submit that they were, as a result of intimidation and fear, made to sign documents that they later came to learn were charge and caution statements for which they now seek to impeach, as they were not procured voluntarily. They argue that the actions were contrary to the Articles 20, 24, 28, 11, 44A and C, 45, 50, and 126 of the Constitution, which guarantees and protects all Ugandans from such inhuman and degrading treatments. They finally submit that as a result of those illegal actions, the criminal proceedings are a nullity. The charge and caution statements be expunged off the record. A permanent injunction against the respondent from bringing any suit in relation to the facts, and they also pray for damages and costs. Respondent submissions. Respondents submitted and first put in preliminary objections. The first preliminary objection is that the respondent raised two preliminary objections, that is, that this application is barred in law, and secondly, that the suit is brought against the wrong party. On the first objection, it is the respondent's submission that the application is supported by a single affidavit which was sworn by Salim Muzamiru, the third applicant, on behalf of all the other applicants, that the applicants allege that they were tortured or subjected to inhuman and degrading treatment, which does not specifically disclose the source of information, which amounts to hearsay. The respondent relied on Order 19, Rule 3 of the Civil Procedure Rules that govern affidavits, which states that affidavits shall be confined to such facts as the deponent is able of his own knowledge to prove, except on interlocutory applications on which statements of his or her belief may be admitted. The respondent cites the case of Electromax Uganda versus Oryx Oil Uganda Limited, business application number 251 of 2020, where it was held that facts deponed to by the deponent of the affidavit in support were not in the personal knowledge of the deponent, and as such, her deposition amounts to hearsay, and the same should be struck out. The second preliminary objection is that the respondent submits that the applicants have sued the wrong party, that they ought to have sued the Attorney General and not Uganda or the DPP. According to Section 10 of the Government Proceedings Act, civil proceedings against the government ought to be instituted against the Attorney General. They also cited the case of Dan Alinange versus Director of Public Prosecutions, business cause number 167 of 2017, and while answering the issue as to whether the DPP can be sued in his own capacity, the court relied on the case of Charles Harry Twagira versus Attorney General and another Supreme Court Criminal Appeal number 4 of 2007, where it was held that the applicant should only proceed against the Attorney General and the third respondent, since the DPP is a government department but is not a body corporate with the powers to sue or be sued. Hence, they prayed that this application be dismissed. The respondent further goes to argue and oppose the whole application by submitting that the applicants voluntarily recorded and signed the charge and caution statements, that the prayer to nullify the statements is misconceived, it is speculative, and can only be determined through a trial and not at this stage through this application. They argue that Uganda's constitution guarantees human rights and has ratified several international treaties. The respondents submit that the applicants were not tortured but were arrested on different dates, that the arrests of the suspects didn't come easily, and it is possible that in the process they sustained injuries but not inflicted for purposes of signing the statements. It is their conclusion that the applicants failed to prove their case by not mentioning exactly who inflicted the alleged harm, and without proof of the physical injuries, and failure to adduce evidence means they have failed to prove their case under Section 100 of the Evidence Act.
Wabula oludda oluwabirwa lwawakanya okusaba kwabwe bwe lwategeeza nti bano omusango ne bagwabidde mu woofiisi nkyamu nga baali balina guggula ku ssaabawolereza wa gavumenti. Mu kino baasaba kkooti egoba okusaba kwabwe. Woofiisi ya ssaababi wa gavumenti y'omu newakanya ensonga z'abano okugamba nti baatulugunyizibwa nga bagombwamu obwala.
That the reports attached fall short of the minimum standard. The report was from a private facility other than that which the court had directed, and even then it's only for only one of the applicants, that is Nagandi Ajara A4, and not all of them. They prayed the same to be dismissed. Applicant submissions in reply to plain objection. In their submissions in reply, the applicants argue that the current application arises from the proceedings of criminal case number 810 of 2020, which were instituted by Uganda DPP, that according to the applicants, the charge and caution statement is part of the evidence in the said matter, which is pending hearing in this court, and that being the position, according to the applicants, the right party to sue is, as they so did, is the DPP. The applicants further argued that this objection is a mere technicality. They rely on Section 6.5 of the Human Rights Enforcement Act of 2019, which, according to them, provides that a suit under the Act should not be rejected for failure to comply with any procedure or any form or any technicality. That they brought the current application to protect their non-derogable rights as enshrined under the Constitution, and they cited the case of Dr. Kiza Besigye and others was Attorney General, Constitutional Petition number 7 of 2007, where the Constitutional Court, according to them, upon establishing that the petitioner's right had been violated, declared the whole criminal proceedings against them a nullity. The applicants further submitted that the cases cited were not applicable as they were from the same High Court. And on the issue of the affidavit evidence and the argument that the applicant's affidavit is defective as it's full of years evidence, they contend that they were physically tortured and that the evidence is attached on record by way of medical reports attached to the affidavit in support. They ultimately pray that the objections be rejected and that the application be allowed for the reasons raised. Court's analysis. This court, as earlier stated, has relied on the submissions of both parties. Upon perusal of the record, this court framed the following issues for determination. 1, whether the application is proper before this court. And 2, what remedies are available to the parties. Issue 1, whether this application is proper before this court. I will resolve this issue in two folds. 1, by determining whether the application by the orders sought and declarations is proper before this court. And secondly, whether the objections raised in relation to the same are sustainable. Before I delve into the merits of this application, I wish to make the following observations in light of the current application. Section 4 of the Human Rights Enforcement Act 2019 vests the High Court with powers to determine applications that relate to violations and enforcement of non-derogable rights, and Section 6.1 of the Act further provides for suits to be instituted before a court where the alleged acts were committed. Rules 5.1a and Rules 6 and 7 of the Judicature Fundamental and Other Human Rights and Freedoms Enforcement Procedure Rules of 2019 provide for who can sue, the nature of actions that can be brought, and the procedure, the content and nature of the application to be adopted herein by anyone who alleges that their fundamental rights were violated. From the above, it can be deduced from the reading of the application and supporting affidavits in support that the applicants want to move court to find that some of them were tortured while in custody of police and gazetted government coffers. That as a result, they seek to annul the proceedings before this court and to acquit the accused and also retract the applicant's charge and caution statements recorded while at police.
Omulamuzi Alex Ajij Makai oluvannyuma lw'okwetegereza ensonga okuva ku njuyi zonna bw'ati agobye okusaba kw'abavunaanwa bw'ategeezezza nti omusango guno baagugula ku woofiisi nkyamu eya Ssaabagambibwa wa gavumenti.
I am aware that this matter arises from a matter that is still under hearing. The orders sought in this application has the possibility, in my opinion, of circumventing the hearing of the main case. This court shall not be allowed to be used in any ways that defeat the justice process. It is my opinion that there is a right procedure under which a charge and caution statement can be retracted and or expunged off the record, and not through an application such as one brought by the applicants. These are serious allegations which ought to be dealt with in detail and specifically proved, as they have the possibility of exonerating the suspects in this serious matter, which involves the serious offenses where the victim is dead. Resolution of reasonable objections. I will resolve the objections, starting with the objection in relation to the applicant suing the DPP Uganda, as it has the possibility of disposing of the whole application. It is the submission of the respondent that the application, as it stands, cannot be sustained because it was brought against the wrong party. The applicants argue that the application is proper before court, that the DPP is the right person to sue for reasons that all proceedings are brought by Uganda, that's the DPP. Article 120 of the Constitution of Uganda, 1995, establishes the office of the DPP. The same doesn't clothe the said office with the capacity to sue or be sued, which, if put in context of the present application, leaves the application with no respondent. I have had the opportunity to read section 6.2 of the Human Rights.
Omulamuzi Ajij omu n'alabula bano obutakozesa kkooti mu ngeri etasaana n'ekigendererwa ekyokulaba nga bataataaganya obwenkanya mu musango guno.
Where a person is in doubt as to the person from whom he or she is entitled to obtain redress, he or she may join one or more persons. Section 6.4 provides that for avoidance of doubt, a statutory notice shall not be a requirement. I'm alive to the law of statutory notice herein, which is in relation only to the office of the Attorney General. And this, in a sense, is a leading provision on who ought to be sued where anyone claims under the said law. I disagree with the interpretation and argument put forward by the applicants that Section 6.5 applies in this circumstance. The applicants do not state or mention in their affidavits specifically who they allege did all these acts to them, if ever the same were done on them. This is in addition to the fact that the DPP cannot be sued, leaves the application open-ended and no one to make orders against. I am persuaded by the submissions of the DPP that proceedings against the DPP cannot be maintained. In the application, the applicants sue and title the respondent as Uganda, that is as a respondent. That is not a technicality, but a point of law. The Supreme Court, in the case of Charles Twagira versus Attorney General, Supreme Court Criminal Application number 4 of 2007, the Supreme Court affirmed the law that the DPP cannot be sued, as the law doesn't clothe the department with legal capacity to sue and be sued.
Ng'asinziira ku nsonga zino ko n'ensonga endala, omulamuzi Alex Ajij bw'ati agobye okusaba kw'abantu bano.
And also I so find that the current application is not sustainable. The Supreme Court guided that such proceedings as the one before court by the applicants are and can only be brought against the Attorney General and all the specific individuals as the case may be. I am of the strong legal view that a suit against the wrong party, as it is the case herein, can't be maintained, as it's not a mere technicality contemplated under Section 6.5 of the Act, and it is as such distinguishable. As earlier noted, this application has only one party as a respondent, who I have since found to be a wrong party. Thus, this is an incurable application, as the applicants can't claim any redress from the respondent. Under Article 252 of the Constitution, it provides that all civil proceedings by or against government shall be instituted by or against the Attorney General, and all documents served on to the Attorney General. Having resolved the first objection in the affirmative, I would be mooting if I went into the merits or making any further orders thereof, having found that the whole application cannot be sustained on the above point of law. In the result, this application is dismissed, the hearing of the main case to be expedited. I so order.
Kkooti yakuddamu okutuulanga ennaku z'omwezi 10 omwezi ogw'omunaana omwaka gwa 2024 nga wano oludda oluwabi lwakweta omujulizi ow'amakumi 20 era ng'abajulizi abalala 15 be basuubira okuwa obujulizi mu musango guno. Suzan Magara yawambibwa ngadde ewaka weerungujja ng'ennaku z'omwezi 7 omwezi ogwokubiri omwaka gwa 2018 wabula oluvannyuma lw'okuwambibwa omulambo gwe gwasangibwa nga gusuuliddwa ku luguudo lwa Mwasanjala olw'Entebbe e Mutungo Kitiko